morning to hear oral arguments in the case of State of Ohio versus Deandre J. Baskerville. Each party will have 15 minutes to present their case. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and you wish to reserve that time, please let me know when you come up to the podium. I'm keeping track of the clock and I will keep you apprised of the passage of time. We're being visually and audibly recorded to be posted online, so please try to remain behind the podium as much as possible. We've read your briefs and we're ready to proceed when you are.
May it please the court, my name is Natalie Neese, and I represent the appellant in this case, Deandre Baskerville. I respectfully ask the court if I could reserve 2 minutes for rebuttal. Mr. Baskerville is asking this court to unequivocally state, contrary to what the prosecutor presented to the jury, that regardless of a person's character, under our justice system, that person will be afforded the same rights as any other person, the right to a fair trial and the right to defend themselves. Your Honor, this was a self-defense case. Under the facts and the law, Mr. Baskerville was justified in taking the action he did. The facts were actually mostly undisputed, and I think you see that when you read both parties' briefs. And it was this. Mr. Baskerville and Terrence met by chance at the Chapel Hill Mall. When they see each other, Mr. Baskerville greets Terrence, says hello, shakes his hand. By all accounts and all testimony, this began as a very cordial conversation. Soon thereafter, Terrence, who was intoxicated, became irate and belligerent and started to accuse Mr. Baskerville of saying something to his girlfriend. Terrence is overheard telling Mr. Baskerville, let's take this outside. Mr. Baskerville says, calm down. You don't have to be like this. That was testified to by a store owner who overheard the conversation. Yet, Terrence followed Mr. Baskerville out of the mall, through the door where Mr. Baskerville's vehicle was parked. Keep in mind, Terrence was parked on the other side of the mall. When they get outside, still irate, Terrence tells Mr. Baskerville, I'm going to drop you where you stand. In essence, threatens to kill him and makes a quick movement towards his pocket. Mr. Baskerville reacted. Now, the evidence was clear. Terrence had a weapon and pulled that weapon from his pocket.
Well, that was my question. Did he actually brandish the weapon? Did Mr. Baskerville see a weapon prior to his reaction?
Your Honor, I would say he did brandish the weapon in the sense that it was found, it was identified as his weapon, it was found out of his pocket.
Did anybody see it out of his pocket?
Nobody, Mr. Baskerville did not see the weapon before he reacted. However, Your Honor, what I would say is that's not what the law requires, is that he see the weapon. It's is it a reasonable belief that he's in danger? And I think when somebody threatens you and goes for their pocket, that's reasonable. In fact, we've heard a lot about other cases, I think in the news, where people pull weapons, whether that's on a police officer. I just read a case in New York, or actually go to their pocket and don't have a weapon, or what they pull is a fake weapon. And we don't require that you see that weapon necessarily before you react.
Counsel, was there any testimony during trial that these two gentlemen had a history? I know they knew each other, but they had a history such that there had been prior threats by one or the other?
No, Your Honor, I don't believe amongst each other there were any history of prior threats. Although there was testimony that Terrence did have a history of being known to be, I think it was a bully and a snake, was the language that was used at the trial court level. Regardless, Mr. Baskerville, upon being threatened, and Terrence going for this weapon had a reasonable belief he was in danger, and in fact, he was in danger. But Your Honor, the case wasn't tried on those facts. I believe the prosecutor went down a road of trying this case where he attempted to inflame the passions of the jury on other issues and attack Mr. Baskerville's character. I give a lot of talk about that in my brief, but there's a couple areas that I think are most important to talk about. And the first was the prosecutor's violation of the other acts rule, evidence rule 404B. Contrary to the law, in Greer, which the state fights, State v. Greer, the court has said, look, if you're going to cross-examine a witness, you can't do it on other acts. But we're going to give you a little bit of very limited leeway. And that is this, is if the defendant comes up to the stand and says, you know, I've been convicted of crimes, but describes them vaguely, you can ask them to describe it more specifically, give the name of that crime. And if the defendant gets up and says, as another example, you know, I pled to all those crimes, insinuating to the jury that, you know, when I'm guilty, I plead, but I'm not pleading now, the prosecutor can specifically address that came up on direct and ask about that plea. But the prosecutor went well beyond that in this case and got into other acts evidence not allowed by Greer. When he got, and I would surmise that in the state's brief, they can't tell you when the prosecutor got into asking questions about, on that weapons of disability charge, weren't you carrying a gun? And why were you carrying a gun? And when you weren't allowed to carry a gun anymore, you started to carry a knife. There was no testimony related to that in direct, nor was that any relevance to this case. Now, the state will tell you, well, okay, maybe we can't draw that line, but it wasn't prejudicial. But I'll tell you, it was highly prejudicial. As the Supreme Court has said over and over again, and I give the example of State versus Shane, is they say, you know what, when we get into this other bad acts, in and of itself, those are prejudicial. That's why we don't want them to come in. Those acts can lead a jury down a road to say, you know what, you're a bad actor. You've been in trouble before. We're going to convict you because of that or because we think you deserve punishment, and not look at the facts of this case. And that's exactly what happened. The prosecutor, in closing, rebuttal actually, came to this jury after presenting that evidence and said, jury, don't rely on Mr. Baskerville's claim of self-defense. Why? Because he's a 7-time felon who engages in criminal activity. Don't wash away his background. Don't wash away his character. Your Honor, that was an attack on Mr. Baskerville's character that requires reversal. The other area I want to talk to the court about is the vague and what I think was a misleading jury instruction on self-defense. The court in this case gave a standard OJI self-defense instruction that said Mr. Baskerville can't be afforded self-defense if he's found to be at fault for creating the situation that led to the altercation. Okay? Now, OJI is often suggested, but I think the courts have long held that, you know, it's not applicable to every case and every fact pattern. And jury instructions are extremely important. Not giving the right instruction or an instruction that could lead to a misapplication of the law needs to be reversed. That's highly prejudicial. And because of the fact pattern in this case, that's what that jury instruction actually did. That jury instruction in this case needed some definition. We needed to tell the jury what that meant as applied to this facts. And because we didn't, the prosecutor was allowed to take that, which he recognized was some vague language, and twist that to represent not what the law actually says. Here's what the law says, and what should have been given as a jury instruction. It's fine to give that OJI instruction, but I think then you have to say, what does at fault and creating this situation mean? And under common law, we've come to decide what that means is you can't be the first aggressor in a physical altercation. What that does not mean is just because you say hello to someone, right? You created a discussion with someone that you're deprived of self-defense. What that does not mean, although argued to the jury, is if I'm a bill collector comes after me or anybody else and they're hounding you for money and you get mad, that you can threaten their life and pull a knife and that bill collector cannot defend themselves. And although the law doesn't state that, the prosecutor presented to the jury that it does based on the reading of the jury instruction that was provided. The prosecutor specifically said to the jury, and again in rebuttal, he gave the instruction that was not defined and said, Mr. Baskerville initiated a conversation or a meeting with Terrence when he said hello. And he came after him. He says he poked him and he poked him and he poked him like a lion asking for money. And he acted like a bill collector. And then he goes so far to say that says the law does not provide that a drug dealer who pokes at somebody or comes after them like a bill collector be afforded the right to self-defense. Now, I think that that statement is wrong on so many levels. But you know what? We may not like it, but that's what the law does. Regardless of who you are, you can ask for something and that doesn't afford you or keep you from asking or defending yourself in this situation.
Counsel, was there an objection to that statement during trial? Sorry,
Your Honor.
I should have had time.
No, that's okay, I'm sorry. There was no objection, and two things about that I would say.
Let me ask you another quick
Sure.
question, because you may or may not need to answer it the same way. I don't recall, was there an objection to the jury instruction or a submitted a different instruction?
In this case, there was not.
Were there any motions for mistrials?
There was not, Your Honor. And so what I would, and it kind of takes me to my next point, but I think is important and that I need to address is there was no objection. Now, this was happening, keep in mind, there was, objections to character evidence coming in prior and it had already been let in. But this happened, the very last thing on rebuttal, and they're not going to get it up to be able to say anything for the defense at that point. But I think that plain error is applicable to this case. And like I said, that brings me, this court, there's a case, State v. Thomas, it was decided by this court about a year and a half ago. It's cited in our brief, it's cited in the state's brief. And I think that supports our case in this situation. In that case, similar in that it was the same jury instruction went in, and the jury, in fact, during deliberation came back to the judge and said, you know what, we don't understand this jury instruction, you need to clarify it for us. And Judge Carr, in her, yes, okay, thank you. Judge Carr, in her dissent, said, advocated for reversal under this scenario. I know Judge Moore wrote the opinion, Judge Schaefer, you signed on to that. And the court in that case wasn't necessarily in disagreement, but wasn't able to get to that point yet because the appellant failed to tell the court what the jury instruction needed to say and explain how it was plain error. I think we briefed, and I told you what the jury instruction needs to say. It needs to reflect common law. First aggressor in a physical altercation. But this was also plain error, especially in this case under this fact pattern, when this is a situation starting with a conversation. That case had an altercation in it. It was obvious that the jury was asked by this prosecutor, again, different than Thomas, to misapply the law, to look at this from a non-legal standpoint. And the criteria is it obvious and prejudicial, or affect a substantial right? I think it was obvious that the jury, this law was being presented wrong. Okay, thank you, Your And I think anytime you don't give a jury instruction where you can apply the law, it affects your substantial right. Ultimately, as I'm ending on time, Mr. Baskerville is asking for simply one thing, and that's for this case to go back without all this other nonsense going on, and for it to be tried on the facts and the applicable law. And then he lives with whatever decision is made. Thank you.
May it please the court, Richard Casay, representing the state of Ohio. And a couple of points where I wanted to address. I believe that when the court reviews the record here, we're going to see about, I conservatively guess about 95% of these errors or issues, there was no objection. So basically, almost in its entirety, this is a plain error case. Now, one thing about plain error, as counsel pointed out, plain error is an obvious error. The case law says that it's so obvious that the trial court on its own should have stepped in and taken corrective action. The state doesn't believe there is anything of that nature in this case. Now, comment by comment. The prosecutor was criticized in closing argument for pointing out Mr. Baskerville's criminal record and said you shouldn't believe him. Well, that's the point of introducing a witness's criminal record, because it bears on credibility. That's hardly misconduct.
What about the portion, the additional question as to why were you carrying the gun? Is that
Sure.
what you are?
This is not an other act. Number one, at page 791, Mr. Baskerville admitted one of his prior convictions was weapon under disability, that he had a firearm. So he admitted he had a gun, he had it illegally. What the prosecutor did was ask, why did you carry the gun? Now the answer was for self-protection, because I got into it with some guys at a bar and I thought they may harm me. So, if you just look at that, the defendant says, I carried the gun illegally to protect myself. Well, he's claiming self-defense in this case, so that's hardly material prejudice to the state's belief. Now, is it relevant? Well, it becomes relevant. And it becomes relevant in this way. So here we have the defendant saying, I had the gun for self-protection. Further on in cross-examination, he says, I had no idea what self-defense was. When I went to West Virginia, after I burned my clothes, took a bus, went down there to do more drug deals, and this is from his mouth, I had no idea what self-defense is. It wasn't until I came back here in the jail, I talked to one of the wise inmates who had beaten the charge based on self-defense. So, I'm thinking, and this is the defendant, I'm thinking my case fits that. I acted in self-defense. Well, he says he never knew what self-defense was, but he says he carried the gun illegally to protect himself. So maybe that is a little bit of relevance as to why those two comments, those two bits of testimony. Now, there was a question, did the Mr. Rogers ever pull a knife? No, he did not. Again, the defendant said he reached in his pocket. He didn't know what was in the pocket. Gun, knife, cell phone, anything that could have been in a pocket. At that point, when he reached in a pocket, the defendant pulls his knife and sticks it in Mr. Rogers' neck.
Do you think there is a difference between just reaching in your pocket and between that scenario and reaching into your pocket after saying, I'm going to drop you, or whatever the exact quote was?
I think the quote was, I'm going to leave you where you stand. I don't know if he said, I'm going to drop you. I stand to be corrected on that, but that's my recollection.
Do you think there's a distinction there?
Leave you where you stand?
And then reaching into your pocket?
Again, if you don't know what's in your pocket, who knows? He thought he was at risk. This, I think, ties into this fault argument, first aggressor. So, Mr. Baskerville says, he reached into his pocket. I interpreted that as a deadly threat. He has to say that because his self-defense claim falls apart if he doesn't. But what did he do? Now, the testimony was that these two gentlemen were in the mall. They were arguing. Several witnesses said that. They came outside and they continued the argument. But inside the mall, Mr. Baskerville reached in his pocket. And apparently, Rogers says, I don't care what you have in your pocket. So if reaching into the pocket can be interpreted as some kind of deadly threat, then Baskerville was in fact the first aggressor because he reached in his pocket to leaving the impression with Rogers that I don't care what you got in there. He threatened him at that point. So when we talk about this jury instruction being plain error, well, no, it wasn't. That's exactly what the law is. You cannot be at fault in creating the situation or the affront. So if reaching into the pocket is outside is bad, it's bad when you, defendant, reached in your pocket inside. Elements of self-defense. I think it's pretty clear that you cannot have a self-defense instruction or viable defense when you violated a duty to retreat. And this gentleman definitely violated his duty to retreat. Again, he went to the mall to pay his cell phone bill. He meets up with Rogers, they have an argument. He goes outside and he argues outside. Friend, just turn around and go pay your phone bill. Why go outside and continue this argument? You're arguing with them in, you're arguing with them going out. You're chest to chest arguing outside. Duty to retreat. He did not take multiple opportunities to retreat.
When he exited, wasn't he exiting towards his car?
Going towards his car, he may have been, but they stopped. You know, that was the testimony of the two minors that heard them arguing outside. So he wasn't going to his car in the sense that he's walking and Rogers is chasing.
Did they both leave at the same time, or did one?
Pretty
leave
much,
first and one
pretty
follow?
much. I think the evidence is pretty much they left at the same time.
So
Because they were arguing in, they were arguing out. So, Mr. Baskerville, who knows nothing about self-defense, comes back and in the Summit County Jail learns all about self-defense. What else does he say? He says, again, this is on cross-examination, I didn't know whether or not I would have to heap up a big lie or not. What does that mean? Well, he said, again, we had to see what they got. We didn't know what they got. What that meant was, he didn't know if the police had surveillance video from outside the mall. He says this. They didn't. So, what can a jury infer from that? He admits he entertains the thought of telling the truth or heaping up a big lie. And I didn't know what the state had. I found out there's no video. I can say whatever I want with what I've learned in the Summertown jail. All of a sudden, I have a self-defense case. The jury, in the state's view, could take that to discredit his entire claim of self-defense. He has put himself in a position where he entertains the thought of lying based on his lack of knowledge of what the state has to prove its case. He finds out the state doesn't have the evidence that apparently he's apprehensive about, because he wonders what they have. Now they don't have it. Okay, I'm free. I can tell them what I learned in the jail, because my case fits. Blood. I want to address this blood argument because it permeates the appellant's brief. Pictures and videos, not one single objection. One autopsy photograph admitted to show the wound. Apparently that's plain error. There's a picture of the decedent on a slab or stretcher as it is first presented to the medical examiner. Privates are covered, bags over the hands. This court has addressed that. That's admissible. Again, no objection. But we're playing, this whole thing is about blood, according to the brief filed by the appellant. Well, there was a lot of blood. He got stabbed in the neck. He sprayed blood. He died of massive blood loss. So, this case was presented to the jury as it factually occurred. There was no conspiracy to convict Mr. Baskerville with oceans of blood.
What's your argument as to the cumulative nature? I think there were 60 photographs, weren't there, of blood?
There's no, well, my answer is I don't know what photographs are supposed to be cumulative because Mr. Baskerville didn't say that in his brief. So I can't address it. If there had been something in the brief where photograph X, Y, Z, and D, and E, and F are cumulative, okay, I can address it. But when it's, all these photographs were inadmissible, I have no argument to address, Your Honor. I do know there was no objection. So it couldn't have been that bad. Certainly not anything that approaches plain error. Again, so erroneous that the trial court on its own has to reach out and stop it.
Well,
None of
when
that.
they're, from what I understand from Ms. Neese's point of view is that he conceded that he was the one that caused the injury. And he conceded pretty much all the facts other than his claim of self-defense. So I think her point was that it was unnecessary because he already conceded, yeah, I did hit him in the neck with my knife. And yeah, he did bleed to death. I don't think there was any contention about that. So I guess my question is, why was it necessary to present all that when he conceded that that in fact happened?
Because the short answer, Your Honor, and you're going to find this in cases older cases that talk about Old Chief, which we now have Old Chief as the law of Ohio. But prior to that, there's plenty of case law that says the defendant just can't stipulate away the elements of the offense. The state is allowed to present its case. The state is allowed to present crime scene photographs. The state, I hope, is allowed to present one autopsy photograph of the fatal injury without without it being prejudicially erroneous. He just can't say, I stipulate everything, I stabbed him, I'm gonna testify and tell you why it was self-defense. I think that's what he would like the law to be, but that's not the law. It simply isn't. I'm probably out of time, so if there are no further questions, I'll sit down.
I guess I do have a question. I'm going to go back just a little bit to the made-up self-defense story, or the fact that he learned about self-defense in jail. When he exited, aside from the deceased, my recollection is that there were a couple of witnesses who didn't exactly witness everything. I don't think anyone would say they saw exactly what happened.
Right, yeah.
Your recollection, did anything either of those people say differ from what Mr. Baskerville testified to?
I don't think anybody, I think the witnesses that you're referring to, Your Honor, were the two minors,
Yes, I believe
Hooks
they were.
and Mustafa. My recollection is, I don't think either one of them saw the actual killing. They heard the argument. They saw Mr. Baskerville running away afterwards. I don't think either one of them, and I stand to be corrected, I don't think either one of them saw Mr. Baskerville pull out his knife and stab Mr. Rogers.
The limited facts they testified to were consistent with what Mr.
Argument,
Baskerville
sure.
said?
I mean, well, inconsistent in this manner because Mr. Baskerville testified on direct that he was calm, cool, collected, and Rogers is just getting in his face. Those witnesses said they were arguing outside loudly, chest to chest. So it was inconsistent in that manner. If I could say one more, go ahead.
Just real briefly, as to the photographs again. The stabbing occurred outside.
Outside.
You ran into the mall and passed inside the mall, bled out inside the malls. Is that the scenario here? There was bleeding from the parking lot to the inside of the mall where he...
He dropped right where he was.
Oh, did he? Okay, now that's what I needed to clarify, so thank you.
Yeah, I'm pretty sure he was stabbed and fell. And then I stand to be corrected.
I thought he went back.
I think
into
the
the mall.
Thunder's correcting you.
Pardon me?
I think the Thunder's correcting you.
I thought he went back into the mall, and you probably
Okay.
know the answer, were the pictures of the blood throughout that whole,
If
from the parking
he
lot.
went back into the mall, the crime scene unit took pictures of everything. If he went in the mall, and apparently he did, then they took pictures of that. If he stayed outside and sprayed blood there, they took pictures of that.
And my recollection was he did.
Yeah, I'm trying to think about this.
All right, you had a final point.
Okay, final point, if I can remember what it was.
Make it quick because we're over though, I think Judge Schaefer is...
I'm done.
I'm gonna give her some more time.
Thank you, I'm finished.
Thank you. Attorneys?
Yes, Your Honors. Just to clarify a couple of things that was just presented. In terms of the suggestion that Mr. Baskerville made up this self-defense argument in jail, I think that there's a couple facts that were left out that are completely go against that. Mr. Baskerville, yes, he left, and he said he was scared, and I think that that was reasonable, given his background, and he panicked. But what did he do? He went to his dad right away, and his dad wasn't home, and he called him. And the testimony from James Baskerville, his father, was when he called, he said, Dad, I was threatened and I reacted. Now, he's not sophisticated, and maybe he doesn't understand the law of self-defense, but right away he communicated that this was self-defense. Sure, when he got to jail, he's thinking, I don't know what I'm going to do, and he's told there's this law out there that protects what happened to you. And he says, oh my gosh, you know what, I don't have to make up anything. I get to come to this court and I get to tell them the truth.
Except
because
for
the
how
law
you explain
protects
the big lie comment that the state made. How does that fit into this?
Right, well, what he testified was, I thought I was gonna have to say something else, because he doesn't realize the law protects him, that he is allowed to react, I think maybe, did I not stab him or something like that? Nobody saw it, but he didn't come in here and say, look, I you know, I did not react. It wasn't me that stabbed Terrence. There's no video out there to show it. How are you gonna prove that? No, he said I did, but here's why. And I think the facts were consistent with that in his actions.
You're out.
Thank you, Deandre.
Thank you.
Thank you for your presentation today. The court will take the matter under advisement and issue a written decision, which will be mailed to both sides, as well as posted to our website and at